Hello friends, in today's session we are going to discuss the case Dolphin International Ltd versus Raunak Enterprises Inc. First, let us briefly understand this case. In the present case, a commercial agreement was made between Dolphin International Ltd India and Raunak Enterprises USA, which did not include any arbitration clause. When a dispute arose, an application was filed in the Supreme Court for the appointment of an arbitrator. The court, while interpreting Section 11, subsection 9 of the Arbitration and Conciliation Act 1996, ruled that when an international commercial contract does not contain an arbitration clause, the arbitrator should be a person whose nationality is different from that of both parties. Raunak Enterprises proposed the International Chamber of Commerce (ICC) Paris as an arbitrator, whereas Dolphin International suggested the name of retired Pakistani judge Justice Dr. Naseem Hassan Shah. The court considered arbitration in Paris to be expensive and inconvenient and therefore appointed Dr. Shah as a arbitrator. Now let us study this case in detail. Answer: Dolphin International Ltd Plaintiff versus Raunak Enterprises Inc Respondent. Reference 1998-5 SCC 1 to 4. Subject matter: this case pertains to Section 11 subsection 5 and Section 11 subsection 9 of the Arbitration and Conciliation Act 1996, which deal with the appointment of an arbitrator in international commercial disputes. Facts of the case: Dolphin International Ltd, an incorporated company of India, and Raunak Enterprises Inc, an incorporated company in the United States, entered into an international commercial agreement that did not include any arbitration clause. Later, a dispute arose between the parties and an application was filed in the Supreme Court seeking the appointment of an arbitrator. The matter was heard by Justice Punchhi. Both parties initially agreed on the name of former Justice A.M. Ahmadi as an arbitrator. However, Justice Ahmadi declined to accept the appointment. Justice Punchhi then interpreted Section 11 subsection 9 of the Arbitration and Conciliation Act 1996, holding that the word may should be read as shall, meaning that the appointment of an arbitrator in international commercial dispute is mandatory rather than discretionary. Justice Mazumdar further elaborated on these provisions, stating that when an international commercial contract lacks an arbitration clause, the arbitrator appointed should be of a nationality different from both parties. Raunak Enterprises suggested that the International Chamber of Commerce Paris be appointed as the arbitrator, arguing that it was an established entity handling arbitration matters. However, Dolphin International Ltd opposed this proposal, stating that it had already been consulting retired Pakistani Justice Dr. Naseem Hassan Shah and had even suggested his name before Justice Punchhi for arbitration. Justice Mazumdar was informed that Dr. Naseem Hassan Shah had agreed to act as an arbitrator for a fee of Rs 10,000 per day, along with additional expenses for travel, accommodation and meals. He also agreed that the arbitration proceedings would be conducted in Delhi. Earlier, Justice A.M. Ahmadi had also agreed to the same remuneration. Therefore, Justice Mazumdar rejected the proposal of Raunak Enterprises, stating that conducting arbitration in Paris would be excessively costly and inconvenient for both parties. Under Sections 11, subsection 5 and Section 11 subsection 9 of the Arbitration and Conciliation Act 1996, he appointed Dr. Naseem Hassan Shah, retired judge of Pakistan, residing at 58 D1 Gulbarg 3 Lahore, Pakistan, as the arbitrator to hear the dispute between the parties on the agreed remuneration. He also directed that the arbitration proceeding be commenced at the earliest. Final decision. The petition was accepted. Legal principle established. Point 1. If an international commercial contract lacks an arbitration clause, an arbitrator must be appointed who is of a nationality different from both parties. Point 2. When one party proposes expensive and inconvenient arbitration while the other suggests a more feasible and cost-effective alternatives, preference should be given to the latter. Point 3. The word may in section 11 subsection 5 and section 11 subsection 9 of the Arbitration and Conciliation Act 1996 should be interpreted as shall, making the appointment of an arbitrator in international commercial dispute mandatory rather than discretionary. Please watch full video, share and subscribe to the channel. Thank you.